Okay, it is time. Chairman Corbett is in Ways and Means, so we're going to go ahead and get this committee meeting started. And Representative Barr, if you'd lead us in prayer to open us up.
Yes, sir. Let's bow our hearts. Father God, we're grateful, Lord, to you for all you've given to us. Lord, we ask that you give us wisdom and discernment as we do the work of the people of Georgia. God, we ask that you be with our families as we are here. Lord, I ask for safety today as everyone heads home on the wet roads. And God, we just ask again that you give the presenters the right words to say. In Christ's name, amen.
Amen. Okay, we'll, Representative Gravely, if you want to step to the podium or the table.
Just the microphone again. Mr. Chairman, if you and the committee permit, I'd like to have two presenters with me, if that's okay. Thank you.
Please.
Just bring it, and if you want to walk around this way.
If you would just have them identify themselves and who they represent.
Absolutely. Thank you, Mr. Chairman, members of the committee. I'll go ahead and ladies first. Ms. Ina Mitchell.
I'm Ina Mitchell. I'm Vice President of Prevention Research Institute.
My name is Barry Schrank. I'm president of Taggart's Driving School, headquartered in Tucker, Georgia.
Thank you for being here.
Welcome.
You want to confirm the LC number for us?
Yes, because we are working off of a substitute.
Okay.
LC 392603S.
Okay, that's what we have.
Okay, thank you, Mr. Chairman. Members of the committee, I bring to you today the substitute to House Bill 1020, and I want to go line by line with some of the changes here because I think this is I sat in the Judiciary Non-Civil many years ago when Chairman Rice, we were addressing the issue of DUI driving in the state of Georgia. We looked at interlock on the first-time offense. We had many opportunities through the criminal justice reform. But I think what we have in 1020 is a very good solution which protects Georgians by offering and requiring a risk reduction program to those so that we can both assess family history, addiction, but also I believe it when we're constantly talking about mental health funding and the need for mental health awareness, that here is something, though it may not be the complete answer, but it's something that could offer a first step with mental health evaluation. So when the committee's ready, I'll start line by line, line 20. As the bill, let me pull it out. Here we'll start with line 20. Reduces the risk reduction program, which is a research-based behavior modification course utilized in approximately 18 other states, from a 20-hour course to a 16-hour course. Research shows very little difference in results between the 20-hour program and the 16-hour program, and I want to explain that a little bit. A lot of times when someone is mandated or required to take a risk reduction class currently at the 20-hour mark. That's usually 8 hours on Saturday, 8 hours on Sunday, and then the final 4 hours on a Monday evening. A lot of times you've got to have this completed if you're on probation, if your court date is coming up. Well, everybody's trying to work. A lot of the requirements require you to continue working. And if that Monday night someone gets stuck in traffic after they have spent all day Saturday, all day Sunday, diligently going to this program as they have been court ordered to do so, and then because of some extenuating circumstance is unable to get there Monday night and could face either prison time or a license revocation, we want to we're wanting to help. We're wanting to put forth a helping hand. We're not trying to throw everything we can to make it almost an impossibility. So we're going to reduce that to 16 hours. On lines 27 to 32, this adds 2 points to a driver's license for a conviction of a controlled substance other than marijuana under the existing open container law, and requires the licensee to complete the risk reduction program. Lines 47 to 49, and if I need to slow down, Mr. Chairman, I will. But going on with lines 47 to 49, it gives the licensee credit for taking the risk reduction program when applying for a limited driving permit. Lines 54 to 89, existing code section for suspensions and conditions for the return of the driver's license for DUI. Lines 87 to 89, it's that same code, same section, gives credit for taking the risk reduction program to obtain a limited driver's license. Lines 93 to 113, it outlines various code sections for the suspension of driver's license for adults and under 21, and adds the requirement to complete the risk reduction program before the issuance of a limited driving permit. Going on to line 160 to 162, to be added under the existing open container law. The language clearly states the term controlled substance, but does not include marijuana in the definition. Lines 189 to 207, to be added to the existing open container law. Language that only the person who possesses or consumes a controlled substance shall be charged under this code section. And again, I want to say only the person convicted shall complete the risk reduction program. Lines 211 to 224, existing reckless driving code section, approximately, this is something I want to spend some time on, approximately 300 tickets written per year because it's so difficult to prove reckless driving in court, but used daily to downgrade a DUI charge. This will require the completion of the risk reduction program as part of the sentence. And finally, lines 238 to 238 adds the risk reduction program to a list of courses available for sentencing courts. It already appears in many code sections. So I want to say this. We know that if someone is pulled over and arrested for DUI driving on a first offense, statistics show, and you can go on saferoads.org, a multitude of different websites that deal with highway safety and motor vehicle safety. That is not the first time that first-time offender has offended. Statistically, they've probably driven up to 80, maybe 87 times before that first arrest or first charge of DUI. So potentially, you could have habitual violators, but have just for the first time been arrested and charged with a DUI. That process now says that within 30 days, you have 30 days, once you are charged and arrested for DUI, you have 30 days to apply for an ALS hearing, an administrative license suspension hearing. That individual will go before an ALS officer. That officer can do one of three things. He can say, you know what, we're going to give your license right back to you. Or that officer can say, we're going to suspend your license. A lot of that has to do with priors or any type of habitual history. But most often, that officer says, we're going to give you a limited driving permit. And I want this to be very clear. At that moment, the state has determined that this particular driver should have limited driving privileges because of the offense, the arrest, or the charge. What we're saying is, at that point, in order to receive that limited driving permit, that the driver would have to complete a risk reduction program in order to obtain the limited driving permit. That program, as I spoke in the beginning, is an assessment of family circumstances. Some of you are very familiar with the risk reduction program. It's an assessment of prior use and abuse of any substance or drugs, but it also can potentially be an indicator or incorporate mental health issues or any factors dealing with mental health and addiction. So this gives us an opportunity to evaluate why this person made a high-risk decision. If they're going to indeed, after we have said they need to be on a limited driving privilege, whether it be for work, for school, for church, the state's already said, we're going to limit your driving privileges. But we're not asking any questions about why they made a high-risk decision to begin with. Now, when they get to adjudication, which sometimes could be a year out, I think we owe it to the tax-paying citizens, the millions of drivers on the road that choose not to make high-risk decisions, that we have required this individual to participate in a program to help them identify why that high-risk decision that endangered other drivers could have potentially killed other drivers. We've at least, the burden of the state is to do that, or at least hold accountable those individuals who we're going to continue to allow to keep driving once they've been charged and arrested with a DUI. If at that adjudication they are convicted, then that risk reduction program will be credited to any penalties. They don't have to take it again. If it is then dropped down to a reckless driving, we already know that there's approximately 300 tickets. Reckless driving is very hard to prove in court. But there are upward of 1,000 convictions of reckless driving. That's because reckless driving has been pled down from a DUI charge. So for those on the roadway, our parents, our families, our children, all we're saying is that those that chose to make a high-risk decision would at least have to participate in a program to help them possibly identify why that high-risk decision was made. Again, that could have endangered that does endanger other drivers, that could have potentially killed other drivers. Mr. Chairman, I'll pause if the committee has any questions on that. If we want to get into the other sections of the bill.
Okay. Yeah, we do have, looks like a Christmas tree up here, so we'll take a couple of questions.
Well, I love Christmas trees. They're very pretty.
Representative Kennard.
Do you have an estimate of the cost of this 16-hour course?
The cost is already set by, the state already sets the cost. It's
Which
statewide.
is?
It's, the two.
It's $200-something.
Yeah.
Okay.
I mean, there's several charges added all up together. It's.
I think average could be between $200 and $300.
Okay, thank you.
Representative Perkle.
Thank you so much. I do like the use of education as a means of lowering recidivism. When we find someone that has a higher risk profile, if we can address that before someone gets killed on the roadway, I think it's a great idea. My question is you're pulling in lines 27, 28. It goes throughout. Risk profile: possessing an open container of an alcoholic beverage or a controlled substance other than marijuana. Are you implying that that marijuana possession does not increase the risk profile that you see with an open container or driving, whatever those with the DUI? We're specifically excluding this from the controlled substance list, and we have not changed our the legality of
Our law has not changed on that. You are correct.
Okay. Is your contention that that they do not rise to the same risk profile, because like I say, hey, if we can get to them and educate the people, that's a great idea. You find people that are at more risk, but then you're excluding a class that, that was my.
Absolutely. Great question. And the answer would be no, we're not doing that. The reason we excluded that in this particular bill was because of the various jurisdictions that have either decriminalized or are not charging for specifically marijuana. And so that's something that I'm not opposed to if it's in the leafy form. What I would not want to do is infringe upon any of the forward movement that we've made dealing with the oils from a medical standpoint. But in no way, form, or fashion would I consider the use of marijuana in that for recreational purpose or anything like that, a low-risk decision. I would agree with you that it is high risk, and for purposes of this bill, that was done simply because of the varying stances that municipalities or counties have taken in regard to marijuana from voting locally from a decriminalization standpoint was the only reason.
Can I follow up there?
Go ahead.
And there again is my point. We have state laws in this great state for a purpose, and I'm just uncomfortable with the step that this appears to be taking. I don't know that I'm uncomfortable. I think that our cities, our municipalities, have a constitutional statutory authority to follow the laws of this state, and I would not. I understand your point, but I would have to disagree with that one. Thank you.
And just so that we're clear, disagree with the policy being put forth in the bill or the omission of marijuana from the bill?
The omission from marijuana from the bill.
Would the gentleman entertain an amendment if it was narrowly written to include leaf form?
So it is your bill. But that was my objection, that it controlled substances. You know, whatever that is, and controlled substances can change as that subsection of their statutes change. But for example, and it's rife through here, but where I was looking specifically, the first instance was on line 28, or a controlled substance, and if other than marijuana were
yes.
stricken, then I personally would be. But there again, I'm one of this panel, and I apologize, Mr. Chairman, for manipulating this conversation. I'm sorry.
No, I think it was a good line of questioning, and I believe that I would have some interest in working with the gentleman if the committee would so deem that to be proper.
Okay. All right. Representative Alexander.
Thank you, Mr. Speaker. And maybe I missed something because I came a little bit late, and maybe you already talked about it, I'm not sure. Is this an additional program? Because we already have the accountability courts, DUI, drug courts, so is this an additional program?
No, this would not be considered an additional program. Risk reduction programs currently exist in the state.
Well, I guess my question would be then, why the purpose? Because there's a lot of things in this bill. It's fees, everything. So it's a lot of things going on in this bill.
I want to make sure you've got the right bill. What LC? We're working off LC 39260-3S.
Yes.
Okay. From a fees perspective, if you could point me to which line you're referring to.
And I'm asking, what is the purpose of this bill now?
This bill, the purpose of this bill is when, as I explained to the committee earlier, when we are looking at keeping our roads safe in the state of Georgia, when we're looking at trying to decrease recidivism, when we're trying to understand why a driver in our state and only a driver would make a high-risk decision to get behind the wheel of a car after everything that we have advocated for, laws that we have passed in the state, the statistical analysis behind the dangers of driving under the influence, the deaths. If I can read this, as little as just as short as 2017, statistics show that there is one fatality associated with a blood alcohol content of over 0.08. That's our legal limit in Georgia, every 48 minutes. So we're trying to understand if we can help these individuals. Currently, when you are pulled over and let's say you are arrested and charged with a DUI for the first time, statistically, that's not the first time you've driven while either under the influence of alcohol or having drank alcohol. Statistically, that is likely between 60 and 87th time, the 60th and 87th time that you've done that, statistics report. So what we're trying to understand is, why is this individual making these types of high-risk decisions? What is it? Is it a family history of addiction? Is it potential mental health issue that maybe we can capture early on and understand how to further help this individual? I think drug court, this would be before the drug court process. And then if we're going to allow an individual who potentially, based on statistics alone, could be a potentially habitual violator, based upon the research that we have, though it was just the first time arrest or first time charge of DUI, the state has acknowledged either they've suspended the license at an ALS hearing or they've given the license back. But 9 times out of 10, what normally happens is we've issued or allowed that individual to have a limited driving permit. So we've potentially allowed a habitual violator to have a limited driving permit. Once we've already charged them and arrested them for DUI, all we're saying on this to obtain the limited driving permit, we are requiring you to take a 16-hour course to answer Representative Kennard's question that will cost between $200 and $300. That is a 2-part series of a risk reduction program that does an assessment of family circumstances, any type of prior use and abuse of drugs and alcohol, and could potentially have indicators for mental health issues, whether it be dealing with addiction or any other factor regarding the individual. That's all we're saying, that we want to know, we want to help, as opposed to just saying, you know what, we've charged you with DUI, we've arrested you with DUI, you've requested an ALS hearing in front of an ALS officer, we've recognized that there is a problem because now we've taken away we've limited your driving privileges, but just go out there and drive if you want to, or you can drive until adjudication. Well, that could be a year, it could be a year and a half. So I think we owe it to the taxpaying citizens of this state, and we have a duty to the taxpaying citizens of the state who do not make those types of decisions, to try and understand why these individuals are putting other people in danger or potentially, God forbid, a fatality by making a high-risk decision. That's the ALS portion of the bill.
All right. Representative Barr.
To my friend, I have several questions, if the chair will allow.
Go ahead.
Okay. I would follow up with my colleague's statement on line 24. With friends in police departments, they have mentioned to me even recently that the pullovers for DUI is not necessarily alcohol at this point. They have significant, they're on pills, they're high on marijuana. So that as well to me is a concern. So just to point that out. The question on line 29 is the 2 points. Are we following something that's already set, or is that a new?
If I can, Mr. Chairman, I'm going to have Barry Shrink
Okay.
answer.
Yes, my name is Barry Schrank, president of Taggart Driving School. I'm a licensed risk reduction instructor. Taught the course as a curriculum with the risk reduction since 1990. Prior to that, I taught a different course, a different curriculum. Was licensed by the Georgia State Patrol, and never has there been for a DUI charge or conviction any points assessed. It was always either you walked or you were guilty. So there are no points assessed. Under this bill, it falls under the open container law, and there will be points assessed.
Okay. Very good. And then I have other questions if.
Absolutely. Absolutely, yes.
Let's jump over to 203. If you don't mind, line 203. So I realize we are we're mandating this program. My concern is not with the fine in 203, but with the amount of time in prison or in jail, probably the better term here. Is there a formula that we came up with 20 days? It seems excessive to me for not paying a $300 fine to be incarcerated for 20 days.
There's no incarceration in the bill. It's just the amount of time they have to apply. Yes, I don't believe the bill addresses incarceration. It just says that to obtain a license through the administrative license suspension process, they have a certain number of days to apply under the existing law. I believe it's 30 days. And what was added there, if a person is incarcerated, they may be incarcerated for 90 days before they get out, and they can't take the course until they get out of jail. So that just extends the amount of time for them to take the risk reduction program to go through the administrative license suspension process.
I'm referring to line 203, and it reads, well, I'll start in 201, completion of a DUI school or drug use risk reduction program within 120 days following the conviction. Failure to complete this program within 120 days shall be in contempt of court and shall be punished by a fine of not more than $300 or 20 days imprisonment or both. And maybe I'm misunderstanding it, but I'm just reading the language on my sheet.
Representative, I believe you're correct. This is a substitute that I have not seen. It just came out, I believe, last night or early this morning. And
and don't get me wrong, I think this is a good bill. I think we're just trying to work through the committee process. If the author has an answer, I would love to hear it. If not, I would see if he would entertain a friendly amendment later.
Well, friendly amendments are always entertainable.
Well, you, sir, would determine if it's friendly or not.
Yeah, further questions?
Because we're looking at the substitute as well. Let me make sure, because we had a lot pulled out of the bill to begin with.
Representative Barr, do you have any further questions?
Unfortunately, I do, but I can pass in deference to others.
Okay. Representative Moore.
Representative Gravely, could you re-explain how this affects the reckless driving plea deals that are so common in DUI cases?
Yes, what we're saying is, if you get arrested for DUI, you request your ALS hearing, they issue you a limited driving permit. In order to get that permit, you have to take a risk reduction program. You take your risk reduction program, you submit proof of that to DDS. DDS issues you a limited driving permit. So you drive on that permit until adjudication. What we've seen, though, however, and what we know is that in the entire state, correct me if I'm wrong, we've seen 300 or less convictions on reckless driving because it's a very hard conviction to obtain. So, however, we've got thousands that are convicted on reckless driving because what happens is they go to adjudication with a DUI charge. And because the officer didn't do this or because of this or because the defense attorney questioned this, well, let's just plead this down to a reckless driving. Okay, but does that mean the individual was not drinking alcohol and decided to drive a car? So what we're saying is even in that event, because of the high-risk decision that the individual made, we would require them to take a risk reduction course or program to try and understand better why they were driving either under the influence or having under the influence of alcohol or having used alcohol when they decided to crank the car and get onto the highway.
In the rare case that someone was acquitted, would they get a reimbursement on that class?
if they were acquitted, would they get a reimbursement on the class? Acquitted, basically you're saying that it was acquitted, it was proven that they did not have alcohol on them.
Right.
I'm going to defer to the two people on the side of me. I guess the answer would be, yeah, it'd be so far down the line that no, they wouldn't be, in the rare chance that an individual was acquitted in that instance.
Okay. Thank you, Mr. Chairman.
Okay. See no other questions? Representative Barr, do you want to follow up?
Yes, sir.
Go ahead.
Representative Gravely, would you entertain a reduction on line 203?
Let me see here.
Of the days in imprisonment?
Yes, I would be friendly to that, absolutely.
I don't have expertise in this area, so I'm only going off of my limited. I think it should be somewhere in the neighborhood of 5 days. I mean, it's a $300 fine. If we're talking, a larger fine number, it would seem more substantial. Does anybody have any ideas? I'm literally have no
I think
legal experience here, but for
Ms. Doldy is our counsel for the committee. And I would not be opposed.
Doesn't have something specifically attached to it. I think it does. We can just say that they're not held in contempt, but that they have, whatever the policy you want it to be. It could be failure to complete in 100 days, be punished by an additional fine of X, or whatever your policy is like on that. Where that comes from, it's tracking furnishing alcohol to minors. So if you don't complete that, it's the same penalty language, that if you furnish alcohol to minors and you don't do it in 120 days, that's that language. So just so you know where it came from.
very good. I would propose 5 days to the committee as an amendment.
All right. Representative Kennard.
Chair, how about community service? 40 hours of community service instead of imprisonment.
I'd rather spend 5 days in jail.
I think that'd be more of a deterrent, honestly.
Yeah. Would we want to carve out Representative Ridley, or would we want to? I would be amenable. I think I would be fine with that as well. Again, the idea of the legislation is to not just increase fines and penalties and punishments. The idea is to try and help the individual and help the state and the taxpayers and those on our roadways. It's trying to help them identify why a high-risk decision of this nature was made. So I'm absolutely workable, and if community service is what the committee decides on, I would not oppose that.
Okay. Well, I guess we have a host of opportunities for friendly amendments, so to speak. So why don't we, when we get to that point, we'll tackle those amendments. So do we have, what's the will of the committee at this point? Or do you?
I'm sorry, Mr. Chair, I did have some other, because we have presented the bill to GACTL, and they had offered 2 amendments that we felt were appropriate for the bill as well. On lines 196 through 198. This deals with, I'll start at 194. Only a person who consumes a controlled substance or possesses a controlled substance in violation of this code section shall be charged with such offense, provided, however, that an operator of a motor vehicle who is alone in the passenger area of such motor vehicle shall be deemed to be in possession of a controlled substance in such passenger area. The passenger area of the car is not just the passenger seat. It's the cab of the vehicle, just to make sure we're clear. So if you have, let's say you have an instance where a mother is driving, or a parent is driving their child's vehicle, and in the vehicle is a controlled substance. and the individual gets pulled over maybe for speeding or, well, we want to have some type of a rebuttable opportunity for that parent or any individual in that sense where you maybe a friend borrowed the car to be able to say, okay, hey, this is not my car. This was, yes, it's in the vehicle, but giving them that rebuttable route. We understood that, and the language that they proposed would be replacing line 196 through 198 with, if we're making amendments at this time, or I can hold off.
Right, I think we need to
Yep,
get to that
absolutely.
point, and we'll address all those amendments.
And then the other there was a suggested change of increasing the time for individual that was incarcerated 90 days, and then we would just double that to 180 days. And that's it, Mr. Chairman.
So, is this something that you'd want to go back and, since there's so many amendments, do you want to?
Well, I only counted, I think, 4. But
now we're tossing around the idea of community service versus jail time. What?
I think we could, with legislative council, we could work with them and maybe step out of the room. If that's, we'll defer to the committee.
Okay.
If we need to take time, or if we need to work on that and let other bills go through.
Okay, 24. Representative Barr?
Propose a 5-minute pause, and we can huddle with if you don't mind, sir.
We can do that. We can pause.
Okay, thank you.
Yeah, I was right. Okay.
Okay, we're coming back out of recess now.
And I want to say thank you to the members for taking the time. I think there was a lot of good input on the measure. And again, I want to stress this. This is a legislative measure to help the individual, for us to understand and evaluate why the individual is making high-risk decisions so that we can better
Gotcha.
protect the taxpayers of this state on the roadway, those who are choosing to abide by the law. So, Mr. Chairman, I would ask, I would be open to a motion to table the bill so that we can then address the amendments that have been
Gotcha.
brought to the forefront.
Anyone want to make that motion? Motion to table. We got a motion to table. Is there a second? Second. All in favor? Aye. All opposed? Motion is tabled. Thank you.
Thank you, Mr. Chairman. My next bill, I'd like, is in another committee, so I need to run.
All right. Okay, you want to present it here or down there?
No, I'm not.
Oh,
We'll
you-
wait till next week.
Okay, so that's it then?
Yeah.
All right.
Hey, bless your hearts.
All right. Meeting adjourned.